In the judiciary, we have magistrates, judges, and tribunals which are toiling and applying the Constitution and our laws as we know it. But then you have a Supreme Court that is turning out to be an oxymoron. It comes out with a decision today, you go and advise your clients, this is what the law says as per the Supreme Court. The next day you go to court on that same issue, the same Supreme Court decides opposite. The Supreme Court is the weakest link in our judicial system today. You cannot even tell what is their jurisprudential value to this nation. Nowadays, this Supreme Court, he has even cases of inheritance. People fighting over a dead man's property. You find the Supreme Court, because the amount involved is colossal, they are assuming jurisdiction and they hear it. What is that? These are matters which were meant to end at the Court of Appeal. Look at the governor petitions. Nowadays, all governors' petitions end up at the Supreme Court. And there's only one outcome from those cases. There is not a single governor petition which the High Court has allowed or the Court of Appeal has allowed that has gone to the Supreme Court and the Supreme Court has allowed. They have always sided with the sitting governors 100% in all the gubernatorial petitions that have gone before the Supreme Court. 100%, not even 99. Why? Are you telling me the High Court that dealt with the matter at first instance, took all the evidence, was wrong? Court of Appeal that, for example, upholds that decision was wrong? That now it is them that all of a sudden they know. I mean, there's a perception here. To begin with, the Supreme Court has no business listening to governor or MP petitions. Their jurisdiction in the Constitution was only limited to presidential election petitions. All of a sudden, it has become a new Court of Appeal. Look at the decision of the Supreme Court of Kenya. There are 7 judges. 99% of the cases they hear, they reach a unanimous decision. 99%. Where is the individual thinking? What is this collegiate unanimity that you don't even find dissenting opinion? In a functioning judiciary, you will expect the 7 judges to each have their own opinion. We want to understand their legal philosophy, their thinking in their writing. They should all write their own judgments. Then we go by the majority. But to them, one judgment is written. The rest just sign. Who writes it? We don't even know. So why do we maintain 7 judges when all we get always just one judgment? Because the beauty of dissent, when you have different judges writing, everybody brings their minds into a judgment. And you can even use a dissenting judge's opinion as a persuasive argument. You understand his legal philosophy, what his thinking is, even if they all arrive at the same conclusion. We want to see their legal thinking, how they've dissected it. Because they cannot, as the 7 of them, have only one mind that writes only one judgment and they all sign. Doesn't make sense. I mean, let's be serious here. We are getting a raw deal from the Supreme Court of Kenya.